Good morning, everyone. Ed Clinton here from the Clinton Law Firm. This is a short update on why we may have declined your case. The main reasons we would decline a case are that the case wasn't finished yet, that there was no attorney-client relationship between you and the lawyer, or three, the lawyer you wish to sue represented an opposing party or was like a guardian ad litem. Let's talk about the first reason. So in order for us to file a legal malpractice case, we have to prove a few things. Main thing we have to prove is that there's a lawyer-client relationship between you and the lawyer that you're unhappy with. We would then have to prove that that relationship caused you damage. So if your case isn't finished yet, if it's still pending, we can't really get involved and file a lawsuit. We can talk to you, we can listen to your story, we can find out what your losses were, but the case is not finished, so there is no malpractice of any kind. We don't have an idea on what the loss was, and we can't figure out if the lawyer made a mistake, if the mistake actually caused you any harm, because in the litigation, the court could fix the mistake. The court could change a ruling. So we can't take a case unless it's really over. Over means it has reached a judgment in the court it's in. So that's the first reason we wouldn't take your case. The second reason is that you have no attorney-client relationship with the lawyer. The lawyer represented an opposing party. The lawyer represented with a guardian ad litem. The lawyer was appointed by the court. There's any number of reasons, and many times, particularly in the family law area, these decisions are contentious. People get upset. They think the lawyer did them in. It may all be true, but there's nothing we can do about it because you don't have an attorney-client relationship with that lawyer. You have to it's very similar to an agent-principal relationship. The principal is the client, the agent is the lawyer. Unless we can define the relationship in that type of legal way, we can't sue. The other one is the lawyer was the lawyer for your company. The lawyer was the lawyer for the entity you were part of. That may not be your lawyer. And oftentimes lawyers will say, I represent the company, not you. That's the case. Once again, you have no legal malpractice case against that lawyer because the lawyer doesn't have a duty to you. There's no relationship. You're not a principal. The lawyer isn't an agent. The principal is the company that you worked for. The agent is the lawyer. So if you're contacted in an internal investigation, company lawyer comes in, he's not your lawyer, he's not your friend. You can't file a case against him. The third reason is if there is no principal-agent relationship, the courts won't let you sue that lawyer for negligence because the lawyer has no duty to you, no duty to protect you, no duty to do good work for you. There's no way to police that relationship. You would have, in the eyes of the court, too many lawsuits from too many people suing lawyers who had no duty to them, no obligation to them. So that's why, those are the main reasons we would decline your case. And it's always good to remind everyone of what those reasons are. Should you have a question, call us. We can always talk to you. We happily talk to people, or send us an email. Thank you very much.